This is, as Michaela said, the first of 6 in a series, and so I hope some of you are able to come back to later in the series. I particularly like to thank Laurie Sorosky, who was responsible for setting up today, and also the college and the Law Foundation. You should have in your possession a paper and also a what we call a bubblegum card or a cue card. For those of you who don't read much more, you can carry the card around. And can I say to you that a number of lawyers that we work with in mediations, they carry these in their wallets, and it's a kind of game. They put them on the table during the mediation and they look up and they wink at you. So they're good things to have. They're worth a lot of money on eBay as well. Okay, I'll try and get you out of here at 9 o'clock. This paper is drawn from experiences as a pracademic, as someone working as a mediator for long term, and pulling out reflections, dictating them back anonymously in case I was subpoenaed, into a dictaphone late at night, and reflecting on things that went well and things that didn't go so well, and then turning them into ideas, and then going back to the theory that exist on all these many topics we're going to look at. You'll see from the paper the first about 7 pages is a general introduction to themes on negotiation, and we're going to leave that and we're going to jump straight to page 7 in the paper. I found that the legal profession particularly likes to have an affidavit in front of them or some sort of document. So I will walk you through this. I won't be reading from the paper necessarily, but I'll try and refer you to the page that we're at. And okay, just to try and summarize the first 7 pages, in negotiation, it's very common, as you know, when you buy a car or buy a house, for people to go straight to solutions. I'll sell you, it's called positional bargaining. It's also called lines. So at the college, we're teaching the students to develop what lines of negotiation. So someone would say, I want to sell my car for $23,000, and that'd be at one end of the line, and then the other would be, I want to buy it for $18,000. And of course, then people engage in incremental moves, and they try and find a number in the middle, not necessarily the middle, but somewhere between, that they can live with, that is satisfactory, not that they're happy with. That's one of the things in negotiation. You abandon language that is unhelpful. That is satisfactory, that they can live with. There's another form of negotiation, which is what most mediators would practice particularly. They're trying to find more chips than just the dollars or the acres that are being divided. And so that's represented by what the language of interest-based, of do clients have more goals than just property or cash? And if so, you try and find more chips. The irony is, having found more chips, you end up with 4 lines instead of 1, 5 lines, 24 lines if it's a complex lease. And then you move along the lines, talking about warranties, talking about cleaning, all the other possible solutions that could exist on each line. But each line tends to have some tension attached to it because people don't want to go straight to a solution. This is the first 7 pages to help you on the lines. There are 6 classic numbers, and good negotiators write these out and keep these numbers hidden, because all good negotiators, as I tell a class, can read upside down. And so it's very important not to have these lines visible. So on each line, whether you're talking about price, warranty, future dealings, you have numbers. The insult zone is with no market support, a crazy number that has no market support from comparative sales or from litigation. The target zone is one that does have market support, and the reservation zone is the one I can get elsewhere, the number I can get elsewhere. Why should I stay here? I can get a better number than that down the street buying a different Toyota, or I can get a better number even before a judge who doesn't like me, or at least on the predictions I've got. So each line has your 3 numbers and the 3 numbers you guess that the other side has prepared. And so the negotiations move, and very often there is no overlap in the reservation zone. So there is a gap, and that is called the last gasp, the last gap. And many of us can tell stories, great stories, about how negotiations go to hell at the last gap. So I had a friend, a very good friend I worked with a lot, and he tells the story of how he was negotiating a family matter for a long time and spent a huge amount of money negotiating, and they got to a final mediation. And the parties worked along the many lines and came to conditional agreements, but the last line that was there was who would pay for the painting of the front veranda before they sell the house. So my friend Rick tells this story, and all of you can tell these horror stories of how they had a quote for the painting of the front veranda, $1,600. They're dividing hundreds of thousands of dollars and many other things. And of course, each of the parties said, well, I've given enough already. You pay to have the veranda painted. No, you pay. And so the debate went on. I've given too much already. And finally, Rick went to his briefcase and took out his checkbook. This is the lawyer acting for one of the parties, and said, I'll pay for the veranda. And what happened next? What do you expect? They both of the parties said no. In no circumstance. He must pay, she must pay. And so they left with the lawyers despairing, and they each spent another $25,000 on legal costs and skirmishes. And at the door of the court, predictably, what did they do about the $1,600? They split the difference, each kicked in $800 and had the veranda painted. So there are many really nasty stories around that, and you can relate them, particularly in succession, employment, insurance, when you're dealing with insurers and you're not an experienced negotiator, when you're what's called a one-off negotiator who's been injured, and of course in family, this happens. All right, back to page 7. There are a few cartoons. I don't know whether you can read that, but that's a great one. We're still pretty far apart. I'm looking for a 6-figure advance, and they're refusing to read the manuscript. So that's the what we call the 2 insult offers there at either end. Okay, what is the last gap or the last gasp? It's the distance between allegedly final offers made in negotiation, across which all parties express strong reluctance to make any further offers or moves. So they both say, I've reached my reservation point, I've given too much. And so what do you do about that? Sometimes people walk out. They hang up the phone, they close down their computer, or they walk out of the room. Walk out included if you're in the same room. They then they put on the table the emotion of, and you're unreasonable. So at the end of the negotiations, you've actually moved backwards, because now you have an extra thing on the table, a bitterness, or they go back and report to their tribal group, I told you they're stupid, I told you they're unreasonable. A great thing to try and do is to organize another meeting instantly before people are at a distance, to say, can Mary and Bob meet in order to look at the new valuations in 2 weeks' time, to organize a meeting where there's no loss of face in the meeting. And then what mediators do, what I do, I say, well, there's so much progress being made. We're not going home, we're going to order pizza. And we stay and we work across the last gap with a number of strategies. And usually that's why mediations end so late at night and why you're drafting at midnight. Why is this such a hurdle? Okay, page 7, the bottom. Why does this get stuck? We've had a number of eminent lawyers phone us in despair themselves, saying this is irrational. My clients are stuck. They're stuck on, it might be the last $1 million on a multi-million-dollar deal, but they're stuck on something which seems commercially so small. Okay, so here are some of the reasons. Page 7 at the bottom. For some people, the deal represents the loss of a relationship. I no longer have to be involved with you as my father, as my employer, as my spouse, as my child. And so this is a loss. So they often have this phrase, oh, but, or there's one more thing, as you're working on the last gap, and you feel this resistance to actually seal the deal. The strongest form of this has been identified by a lady called Iselina Ricci, who's a very famous lady from California. It's called negative intimacy, where a person is intimate with the conflict, intimate in the sense that life is given meaning by hating you, by hating the doctor, by hating the insurance company. And so the last gap represents a true loss, because some relationship is better than none at all. For others, these overlap to some extent. The last gap just represents ending something too quickly. There's some emotional business to do. It's, I need to know why you've behaved that way. I need to know why the insurance company didn't return my calls. I need to know why I've been treated like a cockroach. Can we discuss this? No, this is just about money. Let's cut the deal. So they're going to hang on until they can have some discussion of this hurt. It's not going to go away, and they're going to resist the last gap. This is very important, a very important concept which you're all familiar with. If we deal with the lines, each line represents a shift. I lose. I wanted $1 million. I've now gone down to 920. I've now gone down to 820. I've now gone down to 750. Each line represents a loss, and loss is a very important concept in negotiations. And you can go back to Elizabeth Kubler-Ross and look at the stages of grieving, which are extremely helpful, even though much criticized, to understand what's going on in the room. And so I've given up a lot. I've moved from 1 million, I'm down to 523. I don't want to move on the last 23. I have loss upon loss, and now you want me to suffer yet again. Closely associated with that is the sense of having been tricked. So as a mediator, and I'm sure in your world, you hear this, I'm not moving. I started at a reasonable point. They started at they use the phrase unreasonable point or ridiculous point. So true, we've each moved 6 times, we've each moved 300,000, but now I'm in a bad position because I should have started at an absurd number too. They started an absurd number, I started at what I thought was an okay number. We moved in tandem, and now I'm down their end. So I've been tricked. I ain't going to make the last move, given that I've been tricked. That's very important for lawyers if we're working with clients, or with self, when working with self, is the question, where do you start? Where do you start on the line, or on each line if there are multiple lines? Occasionally in my world, as we get down to midnight and we're sitting around, and we're down to the last $100,000 or down to the last 7 days of a visitation, there is an awkward split in the teams. The clients start to look at their lawyers and they say, well, they don't say it out loud in front of me, but they're saying with their eyes, I'm paying you a lot of money. What are you doing to earn this? We're going nowhere here, and I'm meant to have hired a bulldog. And so the eyes are saying to the lawyers, start blabbing, start being aggressive. The lawyers, of course, have lost interest because the last gap represents less than the combined sum of their legal fees. So they're not interested in fighting about what is classified as minutiae, because they're going to get reported to the Law Society if they start spending more money fighting about a gap which is now less than their cumulative fees. So, but occasionally the lawyers go through a kind of role play of argumentation. It's a play, and they argue the facts and the law and the evidence again, really to show to their clients that they're worth their money. So it can be a nasty revival of the old doubts, you're to blame, breach of contract, contributory negligence, blah, blah, blah. And of course it doesn't achieve anything in getting across the last gap except a lot of noise in the room. And then is the other, we're now on to page 10, the other nasty silence that occurs around the last gap. The nasty silence is the clients start to realize that this is the same number they could have got 2 years ago. And again, the eyes turn to their representatives, and sometimes the statements start to come out in public. And this can be over the phone too. Hang on, this is the same number we were talking about in 2011. Hang on, we've spent 2 years of pain getting to the same spot, and now I bet you're going to suggest we split the difference, aren't you? What have we done here? We've just enriched the lawyers. And that's profound insight. And so the role of the lawyers, and you see lawyers do this very well, and certainly the role of the mediator, is to have some talk at that point to say, yes, sometimes people end up at the same position. Yes, sometimes they're not ready to settle 2 years ago. You can only settle when emotionally people are ready to settle. That's why we're here tonight. Sometimes the right offer at the wrong time is the wrong offer. And so we're now here looking at the right offer, and there's been a lot of suffering since, so can we focus? So you have various speeches which you hope will overcome this sense of recrimination and loss, and of course the beginning of the attack upon the lawyers, the split in the team to say, if my lawyer had been really good, they would have broken my arm 2 years ago and made me settle. And sometimes this last gap is really, dancing around it is a request for an apology. I'm not going to get across here until the insurance company says sorry for the way we've treated you, until the spouse or the father says I'm sorry for the way things have turned out. Another slide to keep you focused. Not only do you look marvelous, but all of you looks the same age. So usually when I'm talking about the last gap with clients, there is a discussion of, but John, can't we avoid this? When we're setting up the negotiation, can't we avoid this tension and getting stuck? And so here are the ways that people say, we can avoid this, or we do avoid it by one of these mechanisms. And can I say to you that all of these, we're on page 11, are defective. They have some merits, and you should have them in your repertoire. As a professional negotiator, you should be able to pull out each of these and say, let's prepare the clients for these tough negotiations. The first one is to use diagrams. Many clients are visual learners. Many lawyers are verbal people. We talk, but clients love to see graphs, and you can talk to them about the lines and the way you'll move backwards and forwards across them. I did a mediation last year where I asked a lady, serendipity, said, how do you learn best, with words or diagrams? And she just said, diagrams, just like that, just snapped back. And so I went straight to the board. I tend to be a visual learner, and I drew 4 lines for her and said, this is what we're going to be doing for the next 8 hours. We're going to be moving backwards and forwards on the valuation line, what's the business worth. We're going to be moving back and forth on the percentage line. What percentage of the business will you get? We're moving back and forth on the timing. On what timing will the business be divided and you get the payout? And what security will there be for payouts over time? And we just put numbers on each of them and said, this is how it will work. And she was brilliant, because she had a set of coloured pens, and during the 8 hours she graphed each of the offers along each of the lines. She was more on top of the figures than her legal representatives. I don't say that in any insulting way, because she was very precise with her diagrams. So she was able to understand the last gap, and that we're going to get to 4 last gaps, and they would be painful. So you can talk and try to help people cognitively to get ready for this, and then emotionally maybe they will be too. Next, the standard one is, we'll keep something in reserve. We'll keep the steak knives in reserve. We'll keep $1 million in reserve. We'll keep the fact that we could pay it to them in Swiss francs in reserve. You keep something in your hip pocket, and you pull it out as you get stuck on the last gap and say, well, and the phrase that's very important, everyone write it in capitals on page 11, what if? What if? What if we were able to pay it in Swiss francs? Would that help? Okay, the what if is the most powerful phrase of any negotiator. If, assuming that, and what if. So insurers classically in my little world, they keep something in reserve. This is their statement as you get stuck on the last $100,000. They say, what if we could get you the check tomorrow morning before 11 a.m. Fantastic speech. Insurers, it's a great what if. They suddenly throw it in. And that's what they've kept in reserve. A maximalist opening offer, we'll keep something in reserve. We'll just start way out here. We want 2.7 million. We want everything. And then we've got something in reserve we can give up. That's very dangerous, because when you start way out, the other parties, if they're smart, will start way out as well. Or the other parties may get so upset they'll walk out. So that one is dangerous, but some people do it. And then there's the famous, well, we won't get to numbers fast, John. We'll slow down the numbers. We'll talk about the goals of the business. We'll talk about the goals of each of the parties in their future transactions. And by talking about goals, they don't have numbers on them. And then we'll be able to creep up to the last gap. Again, that's what I do in my world of being a mediator, but it doesn't save you from the angst, except that you may have created good vibes in the room, that people feel you're listening to them and you're considering them as human beings with all the complexity of their needs in the future. So they are more open to listen when you get stuck on the last gap. But all concepts turn to numbers. All concepts turn to numbers eventually, and so numbers lead to last gaps. So we're now at page 13. So here are the two dogs talking. It's always sit, stay, heal. Never think, innovate, be yourself. So how to cross the last gap. So here we get to the card on page 13 with a range of possibilities. And so what I say to you as professional negotiators or as amateur negotiators is our task is to assist people make wise decisions in the face of uncertainty. Our task is to add value. Add value. We know, like a plumber, that you're going to hit the last gap very often. It's just one of the normal dynamics of negotiation. So how can we add value to help people get across that gap and so on? I think you can add value by anticipating it, by the discussions early, and then when you hit it, by not panicking, by not despairing, by calling it normal, by having breaks, by talking to your client, by talking, if you're a mediator, to both sides. Well, there are many ways that other people work across the last gap. Are any of these useful to you? So I'm encouraging you to learn some of these by heart, have them in your repertoire, be able to visualize them at that point. Don't put up 16. People will be overwhelmed, like buying ice cream, too many choices. But have at least 3 or 4 you can give to them and say, okay, are any of these the least evil of the options available? Can you live with any of these? Because many other people do. So I'll walk you through these, and I'm sure that some of you have others that you could add to the repertoire. So when we have a moment for questions at the end, people can throw in ideas from your worlds that you occupy. All right, add value. Dispassionately and visually brainstorm some of these alternatives. Page 14 now, the first, which I see a lot and is absolutely useless. So be aware of this one. So people, after a long negotiation and you're down to the last 3 days, the last house, the last set of steak knives, they begin to talk. Well, John, don't you know that the precedents say that, blah, blah, blah. Don't you know that the facts are clear, blah, blah, blah. Don't you know that the evidence is these people aren't listening, blah, blah, blah. So they go through a rights talk, a facts talk, a blame talk again. How effective do you think that is after 8 hours of negotiation? It has, in my experience, no one said, oh, I never realized that before. That's amazing. You're so articulate and organized and convincing. Oh yes, you can have the last $20,000. Never happened. What tends to happen is a reverse speech. I give you back rights, blame, facts, evidence. Oh, but I've given so much. You haven't given so much. So if you're managing a negotiation at that point, you either need to cut it off and say 2 minutes each and that's it. I want 2 minutes to repeat. You get 2 minutes. Somebody needs to just cut that off. It doesn't work, even though people would like to say, let's go over the justice, the rights, the fairness talk again. Okay, page 15, the famous one. So you've got there the two, the client and the lawyer. As part of the settlement, your wife is asking for any 3 of the 6 letters of your surname. You, of course, would retain the remaining 3. So the next one is split the difference. The most common way of getting across the last gap. But particularly those of you who are lawyers, you're not getting paid to divide by 2. And the clients at that point are not very willing for you to come up with a suggestion. Let's split the difference, or what about splitting the difference? That's where it may end up. but don't suggest it too fast. So we often come back to that one. Next, page 15, expand the pie, the last gap pie, by subdividing the last gap. So you go then into, will the last gap be paid in installments? What are the installments? A major payment, then minor payments? Will there be security for the installments? Will it be paid in Canadian dollars, or will it be paid in another currency? So you divide up that gap and start discussing how that last piece may be paid or transferred, if it's land, with what kind of security, with what kind of timing. Then you have the famous add-on offer, which is, as I mentioned to the insurers, what if I moved on? You go back into the settlement that's already existing on a contingent basis. We have a contingent settlement, but we're stuck on the last gap. What if I moved on? And then in family, Christmas Day with the children. What if I moved on with payouts from insurers, the timing of the payouts? What if I moved on making it more tax effective by splitting up the payments with more for pain and suffering and less for lost income? What if I go back into what's contingently agreed and try to give you extra? Would you then be prepared to split the difference? So you all would have seen that very often, a very common device. I had a mediation about 2 years ago where one of a very aggressive lawyer came in, and we were dividing a farm between mother, father, Sicilian, that will give you a hint. Mother, father, son, and wife, dividing a farm 4 ways. And the lawyer came in and said to me, and unfortunately I didn't listen to him very well because he's renowned to be an aggressive lawyer, so he always has slick solutions. He says, John, the only way we're going to solve this is by arbitration. We have to arbitrate the division of the farm between the father and the son. I said, thanks very much, Frank. And then I ignored him. And we went on, and 10 hours later we had a settlement. But he was right. The father hated the son so much that we should have worked on the rest of the settlement between the family members, and then left a residual dispute about how much should the son be paid for 18 years of unpaid work on the farm. We should have left that to an arbitrator, because then the father, who hated the son so much, could have blamed the arbitrator rather than the deal that he had struck. So sometimes, only occasionally, this one, in my experience, is good to do. Let's refer the last gap to an outsider, an arbitrator, the head of the real estate agencies in Saskatoon, whatever it may be. Okay, page 16. Now, when this one's mentioned, people usually cower in a corner or throw up. They can't believe, especially lawyers, we're raised in a rational environment, but business people are raised in a success, move ahead, get results environment. So business people are much more open to creative options than we as lawyers, who are very, at least that's my experience, who are very logical and rational. And so I've done this 3 times in mediations, and when we've been stuck, and horribly stuck, I've said, well, sometimes people just, like they sometimes just flip a coin. Long silence. The lawyers are going, what? This is crazy. And one of the clients says, how does that work? and you think, oh, I shouldn't have mentioned this. Well, it works. We say, how does it work, John? You're making up the rules as you go, because you realize due process there may be a real problem if you don't get this right. So you give them some rules about flipping, coin flips, who calls, what win means, who gets the last gap if they win. And 3 times I've used this. People have said, go with it. When we do it, and the winner of the coin toss gets the last gap, got the last gap. And the business people worked out, and they said, we can live with this. The lawyers were aghast, never got hired again in either of those 3 of those cases. It's a a problem of being a mediator always. Why, you have to ask yourself, why is this satisfactory? Why let I had one client who turned to his lawyer when the lawyer was saying, no, and we don't do this. And then there was this loud whisper that went right around the mediation room. What do you mean? You always told me that litigation was a lottery. So this whisper goes booming around the room. It's very, very good, yeah. Okay, so you have to ask yourself, why is this acceptable to clients, to middle managers? I think it's because they can go back to head office and say, we got a solution. We got a result. And the result was based on chance, the last piece of it, but we can now move ahead. We didn't base the last piece of it on reason, on rationality. We didn't base it upon long arguments where we'd have to hire more lawyers. So we got a result. So whatever the reasons, it's interesting when it occasionally works. The other way it works is people are so aghast that you mentioned it, they go back to some of the other options. They say, oh, that's really a stupid idea, John. Let's go back and... Okay, and this one, I've used it once, and a friend of mine who I work with, he's used it twice. And it's both times, all these times the mediations were at restaurants sort of like this. And so this is where you take the last gap, say it's $100,000, and you say, well, one way people sometimes do this is they take $100,000 and they tear up 10 strips of paper and they write 10, 20, 30, 40, 50, 60, up to 100, and they drop them in a hat, and one person pulls it out, and whatever comes out, that's what they get, right? So it's chance, but gradations. And then you have all the rules. Who holds the hat? Who drops the paper in? Who pulls the paper out? So you work out quick rules. And again, some people can live with that, particularly entrepreneurs who are accustomed to quick decision making and getting on with business and not being at fault for caving in at the last point. This one, many of you would have used, particularly helpful in cross-cultural disputes where the intensity of the emotion about principle, about loss of face, I'm never going to lose face again, you can't have the last bit, where you give the last bit, well, what if the last bit is given to a charity? Is there any charity that you're both interested in? What about? Can we discuss this? Can we have a break? Can you brainstorm? Come back with 3 charities that you could live with. Or to a school, and so on. Next, now I want to tell you about this one. This is my favorite. I learned this as a young lawyer, as an article clerk, where I trained. We had 3 years of articles, and I was privileged to be article to one particularly wonderful person. So I had a role model that was extremely helpful. So you would have seen this, but it's important that you know how this goes, because at least in Australia, many lawyers use this number 9. It involves a bumbling Columbo routine. It's an act. Everyone who are the lawyers know it's an act, and they explain it to their clients that it's an act. So you can either do it with a mediator or without. So I'll do the mediator one, but I learned it from a lawyer who did it himself with no mediators around. So you speak slowly and you say, well, it seems like we seem to be stuck on this. We've made so much progress. Yeah, so we seem to be stuck on this last, $120,000. And but you've made a lot of progress. We don't want to lose this progress. Okay, what should we do? Well, can I tell you one thing I sometimes do? It's quite difficult, but you might be interested. It's all an act. It's all an act. And the lawyers are kind of half smiling. They know exactly what's going on, and they're very helpful in this. Say, what if, notice what if, the key phrase to everything in negotiation. What if I went to the other parties who are now in a different room, we've finally separated, because this is so tense, this last gap. And what if I was able, now this will be very difficult. I don't, because I'm taking a risk in doing this, because they may see me as losing my neutrality and being putting too much pressure. So what if I went there and I said to them, and this is going to be really difficult, and so it's all, this is it, because this may take some time. What if I could persuade them to make you an offer to split the difference. I don't think they'll do it, but I could try. If I could do it, and I'm not putting in all this work to bring back that kind of offer and you say, well, you don't want it, you're going to split the difference again. So this is the fear of incremental moves. If someone splits the difference, the other person wants to split the difference. So would you guarantee me that you'd accept the offer if I could get it out of them? Oh, you mean to say they want to split the difference? No, I'm not saying that at all. What I'm saying is, what if I worked with them and could get them to do this? So you blah, blah, it goes on. And the lawyer then turns to the client and says, what John is saying is he'll be willing to go to the other side and try to get them to make the offer, but we have to guarantee that we'd accept it, blah, 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 blah. And so very successful in my world, okay? The routine, one of the rules for mediators, for mediators and negotiators is never be predictable. Well, unfortunately, this one is predictable. And then you go to the other side and say exactly the same. What if I could, I don't think I need to do this, it's too difficult. What if I could go to the other side and get them to make an offer to split the difference? Would you guarantee me accept? You mean they've offered to split the difference? No, they haven't. Not a lie, not a lie. Remember, they offered to accept if an offer came. They get it. So you work with each side and you stay out a long time and you run on the spot, so you're sweating when you go back to each side. and eventually you just walk into both rooms and say you have a deal. No talk, you have a deal. And the lawyers have never reneged in my world, never. They could renege, they could say, oh, I've been talking to my client, it's changed their mind, the guarantee's off. Never happened so far. One day it will, and then I'll be in trouble. But how many of you have seen that kind of routine? Yeah, it's a great routine. Practice it in the mirror, get your bumbling Columbo going. This one, pause and speak to significant others. So this is one, again, I used and have used a lot. People have loss. They have experienced loss. They also experience irrationality and loss of perspective at this stage. All they can see is, I am being screwed down. I am being taken advantage of. So you summarize as a negotiator, we've done very well, we've made these moves, we've got this conditional agreement, we're stuck on this. I suggest that we meet again at 4 o'clock or tomorrow at 9 o'clock or by Skype or whatever it is. You've got to be fairly procedurally strong here because it can slip away. This is going to slip away. Bill, you said you need to talk to your spouse. Mary, you need to talk to your CEO. Okay, I will assist you to have that discussion. We don't want it coming all from your mouth. And we'll meet again at X and we'll look at what are the options to get across the last gap. In my world, this is very, very effective. Often Bill or the CEO is already primed to be on the phone, and so I work through with the tribal member with my language, not with the language of the disappointed client. So this is foreshadowing a later talk, so I'll just switch you here. You don't have this chart that we're about to switch to, and in a sense this is a boutique sale of a kind of problem solving or negotiation style. So this is called a risk analysis, and like most documents with clients, you need to reduce it to one page. So when you talk to the significant other, when you say you need to talk to the significant other, work through the risk analysis. So this is how it goes, and we'll do a whole segment on this later in the series. So you've drawn up with the parties their life goals, and the reverse of every risk is a goal. So you can draw it up in risk talk or goal talk. So you give them the sheet and say, this is a sheet we drew up 2 weeks ago. Your life goal was to get on with life, to open a new business, to invest money, to stop paying lawyers, to stay healthy, to minimize contact with X, the employer or the father or the insurer in the future, to reduce stress on colleagues, your behavior is putting a lot of stress on colleagues, to take a holiday, to focus on my work, to avoid becoming bitter. So we've written out these and we've asked the client to monetize them so that they, 2 weeks before, know what are their grand life goals. To regain control of my life instead of being in the hands of professionals. To settle in the range. I don't want to feel I'm being exploited. I want the market range. And then the last one, to reduce the risk of paybacks. If we keep this conflict going, someone will want to do a payback by an appeal or by reducing contact or something. And then I say to them, well, you've achieved 12 of the goals. The 13th goal we're stuck on. The 13th goal I've just written in there. You wanted to receive a minimum of $540,000. The current offer is $40,000 short. So here's the question. Are you willing to risk the loss of 12 goals to achieve 1? You need to make a decision. Go walking around the block. Go walking around the block with your significant other, whoever that may be, and come back and we'll discuss it again. He's trying to help people get a visual perspective, and the key to these things is to draw them up before the negotiation so that you are confronting them with their document, not your document, not your lawyer's document, not the mediator's document. It is their document. So that's, if you like, a side mini skill that we'll look at later in terms of pausing and speaking to significant others. Okay, how are we going for time? Pretty good. And it's funny how these particular methods become fashionable. This is one I used a lot, maybe 10 years ago. And so this was, we've got stuck on the last day's property, money, and the parties are very stressed. They've been negotiating hard, they're exhausted, but they're not going to make a move on this last point. So I just impose my view either as a lawyer or as a mediator and say, so we're on page 18 here. This is my suggestion. Bill, when's a time when you're available by phone? Between 4 and 6 on Thursday. Okay, I want you to stay by the phone, take no other calls in that time. And Mary and your lawyer, you are to phone together between 4 and 6, and this is the sentence you will say. I'm telling the clients how to behave, dangerous. You will say, as discussed with John at the mediation, or as discussed with my lawyer, we're willing to split the difference. Bill, all you can say is yes or no. You are not allowed to go back to option 1 and haggle about rights, justice, fairness. You can say yes or no. If you say no, we have another appointment the next morning at 9 o'clock to continue the negotiations. Every time I've ever used it, what was the answer? Yes. So pause plus speaking to others plus a scripted offer, no haggling, has led to an agreement. But as I say, I haven't used it for 10 years. It was very popular. It was kind of like the in thing a long time ago. Next, defer the last gap. Say we'll put aside into an investment $100,000. We'll put aside these chattels. And we'll divide the rest. Lawyers hate that because they want to clean up the file and not have this thing hanging over. But in negotiations, you need to have that in your repertoire. And to say one possibility is, it's a bit messy because we end up negotiating about this minutiae, relative minutiae, later on. Next, sell the last item if this is a succession case, division of a business case, division of matrimonial property case. Say one option is to sell the last item at an auction. We can work out the rules of the auction according to precedents, and then the proceeds will be split in either 50-50 or in accordance with other percentages we've already agreed to. So I did a mediation once where I said this is one option, and the guy again says, how does that work? I hate it when they say that. They just straight away, because I don't have the rules ready. So I have to say, I don't really know, but we could make up the rules. He said, okay, sounds good to me. You be the auctioneer, John. And all I could think of was standing before the Supreme Court saying, yes, that's what I agreed to. Yeah, and I didn't, yeah, because you expect some accusation later that you didn't conduct the procedure accurately. But in any case, I made up the rules. They put in bids, and he bought this particular house. It was a farmhouse at a very high price, and he was the top bid, and it all worked out. So there are some stories around that, but this is a common thing that is available in a final settlement. Okay, who knows about pick a pile? Great, a few people know about it. So this is great. This is based on a child's birthday party game. So the wise parent at the birthday parties gives the knife to one child and says, you cut, and she chooses. One person cuts and the other person gets first choice. So very powerful in succession, division of business assets, division of family assets, to say, well, one way we can divide all these assets is the husband or party A draws up 2 lists within 7 days, list A and list B, submits those lists to party B. Party B has 7 days in which to choose one of the lists. Whichever list they choose becomes theirs. And the precedents have all these set out as binding arrangements. If he fails to draw up the 2 lists, then the other person gets to draw the 2 lists and can choose whichever they wish. So a real punitive deterrent to stay in line. And I've done this in trainings with a number of lawyers, and it's very painful to draw up the 2 lists, because on which side will you put the golf clubs? People engage in all kinds of tricks and games. Where will a flat screen TV go? Which side, A or B? Where will a Van Gogh go? Which side? And but nevertheless, it works in some cases, and some judges love it because they do not want to be adjudicating upon what they see as trivia, which is not trivia to the parties, of course. All right, this next one is you as the lawyer, you as the skilled helper, you as the mediator have a tantrum. Carefully scripted, but you can practice the lines in the mirror once again. This is on page 19. You begin in a kind of quiet tone. We have been here for 11 hours. We have negotiated 8 topics to conditional conclusion. We are talking about $17 million here. The last thing we are discussing is the matrimonial bed. You have refused my offer to buy you each a bed. And then the tone gets angrier and angrier with effings and wild wavings of hands. I cannot believe that you could behave in such a way when you have been so rational for so long. And then the screaming starts. And then you walk out and say, I want this fixed when I come back. And you walk out, and you hope that something comes of this. Now, the trouble is, you can do this once a year. If you do it twice, then word's out. Guess what John does? He has these effing tantrums, so just completely ignore him. So my advice to you is never do this. Never, never. I had a friend who did this. We trained him as a mediator. He was a very senior person in the profession. He did this, and with a lot of effings, and the lawyers settled. They were so shamefaced. He came back in the room and they'd settled on the last gap. They then reported him to the Law Society, and it was a big item of gossip, but nothing happened because he got appointed as a judge 3 weeks later, so it was fine. So I'm not recommending this one. This may be what you feel, but don't turn it into a tantrum. You may say a soft version of it. And then the last one, of course, is a very important one to have in your repertoire. Because remember, if you're dealing with conflict as compared to transactions, 4% of the clients need a judge. So they might be in the 4%, but 96% don't need a judge. So there's a speech you need to have practiced. As a lawyer, you need to have practiced it, but don't get to the speech too fast. It's a cop-out, and it also seems to be serving self-interest that you're just churning fees. Some parties need more pain. They are still making rights speeches, justice speeches. They have not suffered enough. And I say this to people as mediator, you're fine people, and what I'm going to say is a hard thing, but I think you have not suffered enough pain yet. You are both still very strong in your language about rights and justice, and you need to suffer time and expense and stress and anguish of this conflict continuing. And in a year's time, you will be at the same place, and you will have this discussion, and you will probably come to a conclusion. So don't despair, just suffer. And it's interesting, a number of occasions I can think of where the lawyers have said to me, John, we just need to take a break. And so out of the room, the lawyers go and they beat up their clients. And they say, you heard what he said. We don't want to be in the same position in a year's time talking about the last X, whatever it is. And so that pain speech may sometimes split the team, which is your job as a negotiator, and the lawyers may say to their clients, we're getting out. So 16 methods. Don't show them all to a client, but you definitely need to learn a number of these and practice them in the mirror, practice them so you can do them and be able to put them visually. Here's 4 on the board for the clients and say, this is what other people do. Are any of these satisfactory? You're adding value. You're saying this is normal. Remember, the great negotiators are able to say, this is normal. You are not weird. Thousands of other people are going through this and finding a way through it. So, conclusion. We're on page 20. Add value as a professional negotiator. Know the bumps like a plumber that are coming when you dig for pipes. Know you're going to hit certain things. Be prepared for them, and don't just say, oh, we're stuck. Say there are a number of ways that people address this particular piece of granite. Anticipate this standard. Remember, normal. When people feel normal, they don't fight so hard. They feel that this is statistically normal, so I'm just in the normal situation. 69% of dentists use Colgate. So that's a very helpful statistic when you're trying to persuade people to use Colgate. And know and practice the methods of the speeches, the visualization of those to cross that last gasp. So the last couple of cartoons. Look, I'm not saying it's going to be today, but someday you guys will be happy that you've taken along a lawyer. And that one's, I like that. While you were out, Stevie Wonder just called to say he loves you. Okay, so that's the end of that particular presentation, and if you want to use the card to remind you of that, I'll encourage you to do that. If anyone didn't get a card, I've got a couple left here. So we have a few moments. I know some people have to fly, so if you want to slip out, do that. If people would like to ask questions or add a comment on methods they've used, and they may be those methods or others, that would be helpful. They're kind of encyclopedias in the room to draw some of the pages out of your experience. So if someone has to slip out to their next event, please do so, but please ask questions. Encyclopedically covered the field. There are no questions left. Yes, please.
Do you ever find that people are too grumpy and they feel condescended by playing games?
Okay, so the question was, do you ever find that people are too grumpy and they feel condescended? Absolutely, yes. They say, we have been playing a game here. We've been moving by increments of $20,000 or 2 items. It's been a game. This is ridiculous. And their response is to just leave, walk out. And now we're playing a game on the last bit. This is absurd. And that's where I think a lawyer or a mediator, the person needs a wise friend with them who can say, unfortunately, this is how it goes. It is ridiculous. Being a human being is crazy. But we're part of that race, and this is how people behave. And the person says, no, it's just him. No, it's not just him. Unfortunately, this is what I do for a living. This is how negotiations go. And they are, in the minds of economists, they are not efficient, but this is how they go. So bear with us, because if we don't do it now, when will we do it? We're going to do this again 6 times before we cut the deal. Let's give it the best shot we can here. And if it doesn't work, you mustn't leave people in despair, because you know that they're going to settle. They're not going to, so few people are in the 4%. You say, well, how can we arrange to have another meeting without losing face? To walk out is a disaster, because when you walk out, who makes the first phone call? If you walk out, the person who makes the first phone call loses. So you mustn't leave your client in the position of making the first phone call. So always try to say, well, my client's stuck at the moment on this, and then go glass half full. We have made progress on A, B, C, D, E, F, G, but we're stuck on F, or whatever we're stuck on. And then actually set up the meeting. Can Bill and Jane meet in 3 weeks' time, Friday the 21st, have coffee and discuss, and then pick a topic. It can be a fake topic. New valuations, how the goods would be carried from one place to another. Some trivia, but don't leave that meeting to be set up by a subsequent phone call, because he who phones first after a walkout loses, because the other side interprets it as, even if it's not, they interpret it as weakness. Is that enough?